workshop. And
Pamela, is it appropriate for me to share a bit of what sounds like good news going?
great, there's some good news.
So I got a call just earlier, an hour or so ago, that it looks like that add to their of a system changes amendment bill that's going section 7 officials in the government out, and I know you had a
Yeah.
That's right, and some quite implications. I know Brent's been put pretty hard for that. So look, it's just a bit of good. I think that's
Oh. Can you hear me online? I hear.
Yes. Sometimes you get loud, like Chris, I didn't hear everything he said. Then he got so loud and then he disappeared again. So it's up and down, Pamela.
Yeah, it's dodgy. It's dodgy.
saying I'm
Not
dodgy.
what's being said. Not what's being said. Just the just the feedback.
The sound, eh?
All
Right.
dodgy.
All right, we are on page 42 is what I've got. That's the number I've got for the Manawhaka Hono Arohi invitations and approach.
Thanks.
Molly.
And what was the gist of what Chris said? Just a one-liner?
Okay, so just to repeat it, we've just got notice that it sounds like that the Section 70 issue that we've been raising with the government that they needed to get into the RM amendment bill it sounds like it's going through this afternoon. This is absolutely critical for how it might apply to some of our farmers. Brent's been having this discussion for quite some time. It means that if PC1 comes out, they can actually it means that they might be able to have rules related to permitted activities as opposed to foreign consents. There's a bit of nuance involved in all of that, but it's pretty important, and it sounds like it's a very last minute amendment that was being rushed through by staff or by officials this afternoon, and I had a call from the minister's office, so that tells me that someone, I think our chair might have had a positive influence on Mr. Disler.
Oh, thank you.
Pleased with that outcome. All right. Matter at hand.
Thank you, Madam Chair. On other Resource Management Act matters, Manawhaka Hono Arohi is a formal agreement under the Act. It sets out how councils and iwi will work together in relation to RMA functions. Under Section 58.0, an iwi authority can initiate an agreement at any time, and once initiated, the council must do a couple of things. It must meet with the iwi within 60 working days of initiation and conclude with an agreement within 18 months from that date. In our region, there are 31 iwi authorities that we have identified in our database who primarily sit within the region, and there's a further 33 iwi with some interests. So we thought it's important to identify the number of iwi authorities in the region because there's potential that we'll get more iwi lodging initiation with us over time. To date, we've received 7 initiations, 1 from Ngāti Tūrangi Tukua, 5 from iwi from the Hauraki area, and also 1 from Ngāti Mahuta ki te Hauauru, who are located on the west coast around Taharoa and are a hapu of Waikato Tainui. Why have we received 7 initiations within the span of a couple of months? It's likely because of the pending changes to the Resource Management Act and the fact that we have are uncertain about what might come of the changes to the Act. And so getting in before those changes is likely what's driving the initiations. These provisions have been in place since, I want to say 2017, so a long time, yet we've only just started receiving these requests to enter into these discussions. So the clock is ticking on all 7 of the agreements to complete the process within 18 months. Next slide. Mana whakahono arohe must include how iwi will participate in RMA policy and plan changes, the process for appointing hearing commissioners, how the parties will work together on monitoring and compliance matters, conflict of interest processes, and also dispute resolution. There's also some optional things that mana whakahono arohe agreements might contain. I won't get into too much detail regarding those. And sorry, I should have mentioned right at the beginning, we're really, it's really useful that Paul Beverley has been able to rejoin our meeting. So once I finish making some really brief comments, I'll hand over to Paul to cover anything else and answer any of your questions that you might have. Just diving into a bit more detail on the initiations that we've received. So Ngāti Tūrangi Tūkua initiated their discussion with us back in April 2025. We've already had an initial discussion with them. You might recall receiving directly the email from Ngāti Tūrangi Tūkua because it came to all the councillors directly requesting that meeting. In the end, governance representation was through our chairperson, who was available. The constituent councillors were also invited along, but unfortunately couldn't make the date. So that initial hui was convened by Pamela, Chris, myself, Neville was there also. Ngāti Tūrangi Tūkua identified 2 things that they're quite interested in for inclusion in the agreement, other than those mandatory elements under the RMA. So the flood protection scheme of the Tongariro River and biodiversity are the 2 additional things that they're interested in. Tūrangi Tūkua are really keen to host council in Tūrangi to have these further discussions, and so we'll factor that in to induction that will happen post the election. And we're also putting together a working group of staff to continue developing up a mana whakahono arohe draft. Next slide, please. Hauraki iwi. So 5 of the 12 iwi that are party to the Hauraki Collective have initiated with us, but also with other councils. Thames Coromandel District Council, Patamata Piako, and Hauraki District Council. So we are looking at a multi-agency discussion in this space with multiple councils, multiple iwi. Whilst not all of the Hauraki iwi have initiated, there is provision within the Resource Management Act to invite them to the conversation, and or if they are submitting or initiating a mana whakahono arohe kōrero at some point in the future, council can also direct them toward a collective agreement or an agreement that might already be in place. Thames Coromandel District Council staff have been leading this process to date. So we are working with them to identify potential dates where we can have an initial hui and discussion with Hauraki Iwi. Like with the Ngāti Tūrangi Tūkua hui, we will be looking at inviting governors to that as well. Next and final slide before handing over to Paul. Looking at Ngāti Mahuta, who also initiated fairly recently in July. We are yet to convene the initial hui, but have identified a date that suits council. The 23rd of September, we've looked across calendars of the executive team, of our councillors, and this is the date that lines up. And Ngāti Mahuta are happy to go with that date. So you'll see in your calendars a commitment on the 23rd at Te Kō, and that's over in Aharoa. So everybody's welcome to come along to that initial hui. The letter in your workshop papers includes a number of things, a proposed agenda for that initial meeting, and also Ngāti Mahuta have done a considerable amount of work already to develop up what a draft mana. And listed on the slide here are some of those things that they'd like about with us. I might just pause there and invite Paul to add anything else, and then we'll also take questions.
O tēnā koe, Māli, and Madam Chair and councillors. So I don't have too much to add, really. I think the key thing I would say in terms of previous experiences with mana whakahono and similar agreements is, so I think as Māli said, the Act, if the council does receive an initiation letter, the Act requires the council to enter into an agreement within 18 months or such longer time as the parties may agree. And while the Act also prescribes what must and may be included in the agreement, there's considerable flexibility for the council and the iwi to together decide what topics to cover and what obligations and processes are appropriate. So the council does have a lot of flexibility through this process as it moves forward. And often what we see through the agreement, these types of agreements, is something that's actually helpful to both the iwi and the council, which is just to clarify how different processes are going to work. For example, RMA planning or resource consent process, clarify points of contact, clarify how information is going to feed in. So often I see them as, or have observed that they are quite useful coordinating mechanisms to make the processes for both the iwi and the council easier. So, but look, I don't have too much more to add from that, Māli. Thank you. I'm happy to assist with any questions supporting you if that helps.
Warren.
Thanks, Pam. Māli, is there any other council around the country that has entered into one of them? And would it be possible for us to see a copy of one of the agreements, just sort of things and how those get and iwi hapu plan?
Yeah, that's a really good request. There are several mana whakahono arohia across the country. There is one within our own region, and in fact with one of the initiating iwi, Ngāti Tūrangi Tūkua have entered into a mana whakahono arohia with Taupo District Council. So we'll get our hands on that and circulate it, as well as a bunch of others. Yep.
Ben.
Yeah, a number of questions. So we've received one from Ate Mahuta ki Hararu, which is a hapu, Waikato Tainui.
Who cares?
Just allow me to
Sorry,
speak, thank
just-
you.
Katrina, Ben is just asking for some clarification.
As I understand it, there's up to 180 hapu within our region. is it likely or possible that each of them could just wakahono?
It is my understanding, and I will get Paul to add, because he's the expert on these things. But I believe that in order for hapu to enter into these agreements, they must have the backing of the iwi. And so in this case, I understand Waikato Tainui has provided that endorsement to the hapu. So that will limit the number of hapu that can legitimately enter into these discussions. They would have to have the backing of the iwi.
Can I just ask a more question on
Yeah.
that? Through you, Madam Chair. There's two in the list on page 43 of the agenda. The first one and the last one, number 7. So we're looking at 58.0. It talks about an iwi authority, and Marley has just talked about having the permission of the iwi authority to ask for one. So where is that provided for in legislation? Just I've been trying to follow it, and I thought that it could happen, but it's not mentioned in anywhere in that 58.0 of the legislation, how that actually works, because probably share similar concerns, 180, 150 agreements. Not that I'd be afraid of it, but it's actually the ability of council to
Resource.
the
to
resource
resource
and
it.
manage that. So it's just to understand the legislation a bit more, please. Sorry, Ben, but
No, that's fine.
it's the
Yeah.
same point.
I'm hoping that Paul might have the specific piece of legislation at his fingertips, so I'll throw to Paul.
Oh, yeah, thank you, Marlene, through you, Madam Chair. So, yes, the position under the Act is that it is iwi authorities that can automatically initiate a mana whakahono with the council. When it comes to hapu, the way that the Act is structured is that the council can initiate a mana whakahono with a hapu. So if it's a hapu-based agreement, the council has to agree essentially to, and that's in section 58p4. The council has to agree to that mana whakahono process with the hapu. So that's the way in which legislation works.
Does that mean that if a hapu applies, we could turn that down?
I believe that's what that's what the legislation means. Yes.
Okay, so
The hapu could. Oh, sorry, I don't mean to interrupt you.
no, it's fine. So basically, it's the iwi that initiate, but not the hapu.
That is the way the legislation is structured. It's also possible, of course, for an iwi to seek to initiate, but have the hapu under its umbrella and then agreements proceed under that umbrella. There are lots of structural options to achieve that outcome. But yes, Councillor, you're correct that strictly speaking, the council could say no to a hapu initiated mana whakahono request.
Because my concern is that we currently have JMAs and they are taking a lot of resources as it is, and that we are due to have treaty settlements for the West Coast harbours at some stage, and we're also due to have treaty settlements for Hauraki, which will presumably require JMAs to be set up. So how do we resource this, and how do these sit within, and can we simply say, well, Hauraki, you've got a settlement coming up which will require a JMA, which will do all the things you're requesting. Why would we enter into these agreements in the first place? Because we've got 18 months and we have to agree. We have to discuss and agree. We don't necessarily have to accept, do we? I'm just asking the lawyer. Thank you.
Yeah, thank you. Through you, Madam Chair. So the council is required to enter into a mana whakahono. So there's no So if we just take Hauraki for an example, Councillor, yes, there are treaty settlements waiting to be passed, but separate to that, the iwi, which you have these iwi have initiated mana whakahono in the list on page 43, the Hauraki iwi. the council's required to engage in the process and to agree a mana whakahono with that iwi. The contents of the mana whakahono is what is up for discussion, if that's helpful.
So what is mandatory to be in the mana whakahono in, for example, the Hauraki one?
So the Marley pointed to this bit earlier, but the compulsory topics are RMA planning, consultation in the context of that, monitoring, how to uphold treaty settlement legislation, and managing conflicts of interests and resolving disputes. So that's the core. And then the legislation also says you can deal with consultation and resource consent related matters, notification, and then any other matters that the council and the iwi agree to cover under the RMA. So there's some. The council can you have to include those compulsory matters, but there's scope for those other voluntary matters to be discussed.
It's just looking through the Ngāti Mahuta template, which they've sent through to us. They're seeking requirements that we must appoint cultural monitors to secure monitoring rights, and that at a minimum, tangata whenua expertise should be resourced to the same degree and same manner as other technical subject matters. There's quite specific demands or requests being made in here, and I just wonder, do we have to implement those, or is that up for discussion, or where are these processes at?
So through you, Madam Chair, yes, that's a very good question. So those are matters that are up for discussion, all of them. So they are to be worked through. The process often, of course, involves very important input, as Marley said, from the technical teams within the council. So RMA planning or monitoring, and then it's up the council and the iwi have to negotiate and agree each of those topic areas. So yeah, it's they are up for discussion.
And some of it seems to be around the fast track approvals process, and sand mining is one of the issues that's mentioned. So where it's more than minor, they're required to be an affected party. So there are significant issues here that also relate to government agendas in terms of fast tracks and things like that are becoming very complex for council and will require considerable resource. So at what point do we have to commit significant funds to implementing all of these?
Maybe just to start answering that one off, we've got 18 months to get to an agreement, unless both parties agree to extend. So that's the time frame. We're right at the beginning. We haven't even had the first discussion. We've just received the initiation that includes a potential agreement from every perspective, and we still have to go through the process of the discussion and negotiation. We will be involving relevant staff across the organisation that have responsibility for all of the things that have been identified, and we will be identifying resourcing implications, systems implications, all of those things, so that when we do come back to council, there is the depth of information that you're going to need to be able to make sound decisions at critical.
But
We
what
haven't
we're
done
talking
that yet. We haven't done that
What we're
assessment yet.
talking about, though, is a number of these that are all coinciding. And so in 18 months is what I'm hearing from you, that we'll have an indication of what this organization will need to resource. So kind of aligns with the embarking on the next LTP. But if all of a sudden in that LTP, you've got to resource this level of joint engagement, nice word, that could be considerable impact on ratepayers. Yes.
We can't give you any indication about costs at this early stage. We haven't done the assessment. It could be,
But we know that we couldn't accommodate it in our current resourcing that we already apply to our engagement with our iwi partners, right?
potentially to the extent that is being sought by iwi, but it depends on the scope of the mana whakahonua rohe that council and iwi land on. For example, the minimum through to the all of the minimum plus, there is going to be quite a difference in resourcing required for those things. So it really is too early in the process to give any indication to council whether we're going to be seeking resourcing for these agreements.
Except
I think it would be unlikely that we're seeking nothing now.
well, no, that's what I want to know about, because we've got a very detailed one from Ngāti Mahuta, which is actually setting out an agenda. They want to run through the draft. They want to work out who's going to negotiate, how soon can we negotiate. And it's in a lot of it's relating to the Alliance Sands and the fast track process, obviously, but they are requesting that we provide them resourcing for this, and that and all provide cultural ambassadors, etc. I mean, so there's a significant request in here already. Presumably, all of the others will have a similar model to follow, based on what the JMAs are like. So we're effectively doubling the number of JMAs when we were already the council with the largest number of committees and the largest number of meetings. All of these are requiring, this one wants to meet at least twice a year. And from what you can say, Paul, there doesn't seem to be anything we can do to minimize the amount of engagement we have.
Thank you. Through the chair. So I think what's going to be sensible through this process is obviously to look at efficiency. So there might be certain types of processes in the planning area that could be run in each of the mana whakahono. So in the mana whakahono that have been agreed to date in the other similar agreements, some of those processes are pretty similar to what the RMA requires anyway. So they're more streamlining and but sorry, to answer your question more directly, if a request is made, the council has to decide whether to accept that and agree to that request or not. So you must enter into the agreement, but as I said earlier, the contents of that agreement are up for negotiation and agreement.
From what I read from section, so firstly, the mana whakahono that have been agreed appear to be in other regions which, unlike the Waikato, don't have treaty settlement provisions that require JMAs.
So just through the chair, so no, respectfully, that's not correct. So the Tūrangi Tūkua mana whakahono rohi is in the Waikato region. It is in the area of Tūrangi and Lake Taupo, which is already a settled area, and already, in fact, is subject to there's a mana whakahono rohi at the southern end of the lake, and then of course there's the recent one which we will know about, which is the joint management agreement between the Tūhoretoa Māori Trust Board and Taupo District Council. Those overlap.
I just wanted to step you outside of the Waikato. From what I looked, there is some in the Bay of Plenty, there's some elsewhere in the country, mana whakahono, but those areas do not have treaty settlement provisions that require JMAs. They don't already have 5 existing co-governance committees fully funded by the council that have to meet 2 to 4 times a year.
Through the chair, no, that is correct. So the other probably main mana whakahono or bigger one is in Ngāi Tahu, in Portini Ngāi Tahu. That already has other structures and other committees involving that iwi, but you're correct, Councillor, not a joint management agreement specifically.
Yeah, so we're being overlaid with our existing JMAs with another whole suite of mini JMAs. Well, they're not mini JMAs, they're potentially going to be very similar, requiring resourcing and meetings, etc. So I just wonder, at what stage do we agree to discuss but choose not to make these extensive?
Well, it's not a decision that we're being asked, we're asking council to make today, because
We've been given an attachment with a proposed hui, which is going to be held shortly.
Yep.
Where we are being asked, how are we going to go about this? What are we going to do? Who's going to be involved? So we are being asked this. This is our one chance to discuss this. So I'd just like to get some clarity. I mean, Paul, in terms of section 58R, once a mana whakahana has been settled, it can't be deleted. However, in the negotiation stage, item 2, there's an ability to allow for a deletion of an agreement. You want to explain that? 58R.
58R, so thank you through the chair. So, sorry, what particular parts are you talking?
So
What, 58R 1, 2, 3, 4, or?
58R,
Are you in the
58R 2A1.
So this is thank you through the chair. This is the dispute resolution process for a mana whakahono. And that what that requires the parties to think about is if there's a dispute and you need to draft into the mana whakahono, to what extent could one of the outcomes of that dispute be an agreement to alter or terminate the mana whakahono? So, but the mana whakahono can't be terminated in and of itself under subsection 5. So, sorry, sort of quite technical and overlaps a bit those provisions.
Well, it
But,
is. And so can you explain that? Because that's quite crucial, because it seems that once the agreement is entered into, it can't be terminated and it can't be altered.
Well, so through the chair, so it can't be unilaterally terminated by one of the parties. It can be altered a bit similar to a JMA by way of review, and if the parties agree to alter it. But the yeah, so I've sort of struggled a little bit with that 2A, what that actually means, because it says set out the extent to which the outcome of a dispute resolution process may constitute an agreement to alter, which is fine, or terminate a mana whakahono, and then it refers you to subsection 5. So I think that the position the council should proceed on, and my recommendation would be that you cannot unilaterally terminate these agreements. And if I may just add, this is why they were put in 2017, was to try and encourage some more uptake of agreements with iwi, because that was seen as lacking at the time.
But I don't know if it was seen that it would happen in the one region that already has JMAs.
Oh,
That's for you, Paul.
oh, for me, sorry, thank you. Through the chair, yes. Look, I'm not sure I can answer that whether people saw that or not. Yep.
Okay.
I mean, if I may say, there are the mana whakahono applies everywhere around the country. While there are JMAs in the Waikato region, there are similar types of agreements in almost all regions that I work in. Similar type, they might not be called joint management agreements, but there are some detailed and significant relationship agreements that mana whakahono potentially overlay as well. So I don't think it's unique to Waikato, if I may say that.
No, but we've been called to a meeting for the initial hui for Ngāti Mahuta, and it's a very detailed proposal that's put there. So what does council have to agree to in terms of the mana whakahono rules?
Thank you. And yeah, just through the chair again, no, that's a good question. So obviously there must be a hui within 60 working days of the initiation, which Marley has explained. And then what the Act requires is a discussion and hopefully agreement on the process for the negotiation, which parties will be involved, and the times by which specific stages of the negotiation will be completed. So again, it is that first hui is just a starting point. The initiation letter has been received. There must be a discussion about how you're going to go about these discussions and negotiations, but it is still very clear that the substance of the negotiations and the contents of any eventual agreement must be negotiated and agreed. The council's not bound to agree to any particular outcome. It's bound to enter into an agreement.
Okay,
Yeah,
so-
Paul, can I just paraphrase that,
yeah.
Chris McLean here? So I think what you're saying is that we need to go and attend this initial meeting. We don't need to go and meet all their expectations of what's at the meeting, but we must enter into it in good faith and be prepared to at least discuss what's in the legislation as the minimum requirements, such as the Schedule 1 planning processes and whatever.
That's
And
absolutely
what we need
correct, Chris.
clarification
Yep.
on. Yeah,
Yep, that's absolutely correct.
thank you.
Oh, I just need a mic there. Yeah. Yeah.
Thank you.
But now you got stereo.
Sorry, I'll break it if I do.
Go ahead.
Thank you. Just on the point, whether it's now, because I don't want to take up Paul's time because he's probably expensive as hell. The reality going to this meeting in September, no doubt will take a whole lot of staff and councils have been invited. The reality for me is, okay, have the first, get to know, rub some shoulders and so on. But my point that I've been trying to make for months, maybe years, is that councillors need to be upfront in that initial discussion once it comes away from that meeting so that we can say, yes, we are happy with this direction going forward. I'm really concerned many actually turn up out there because if we're all going to sit around and listen to, because it's not going to be the meat, but we need to form a relationship. So I think we need to think about how we approach that meeting in September and who actually attends. But yeah, just on that. So with Ben's questions, look, I'll leave it for now, but I'll come back to it. I'm just concerned about what's trying to be achieved. And maybe that's the time for that discussion or post that discussion in September.
And I'm concerned about the expectations that we will raise and how we will resource it.
Exactly. And one of the things I was thinking about was the next council during the LTP, they need to think about reprioritising what $600 million that we already apportion to iwi relationships and the likes within our budget in the LTP. We may have to reprioritise that.
Okay, we don't pray. That's not our budget, right? Just, I
there
don't want
was-
that on record,
there
that
was
somehow
almost-
that's our budget.
There was over 600,000 in the last LTP, and by the time we added a few other things.
Yeah,
was
you
that-
said 600 million. So
Oh, did
just,
I say million?
I
Oh,
just wanted to,
well, maybe
let's
it's,
just arrest that.
okay, 600,000 to $1 million. Can't meet them with the resourcing. We need to look at how existing budgets, what's their need.
I've got Katarina and then I'll come back to you, Ben. Katarina.
It's okay, Pamela. I think Paul answered a lot of the thoughts, so thank you.
Ben.
So Paul, just to clarify, it seems to me 58N guiding principles is the only document that we need to follow. There's nothing in the rest of the legislation apart from the fact once it's signed, it can't be terminated or changed. That we need to look at what the guiding principles are and how they relate to what I think are, well, somewhat extravagant requests from Ngāti Mahuta, and we may find the same thing coming from the Hauraki tribes as well.
Thank you through the chair. So That's correct, councillor. So guiding principles are clearly, that's what they're there to guide initiating development and implementing it, the mana whakahono, but the contents of the mana whakahono also need to be considered under section 58R 1C. So those are the matters that as a minimum have to be addressed in the mana whakahono, and then the matters down at 58R4 are the more other optional matters that can also be addressed.
Given that not everyone has the RMA open, could you just let us know what are the ones that must be addressed?
Yes, through the chair, I'm happy to do that. So, RMA planning, preparation or change of a policy statement or plan, how the council will undertake its consultation requirements in relation to RMA planning, methods for monitoring under the RMA, any matters required to give effect to relevant iwi participation legislation, which is really the treaty settlements, identifying how to manage conflicts of interests, and then resolving disputes. And the voluntary ones are really about resource consents and other powers and functions under the RMA. So there's an ability to extend it there. In the Taupō District Council, mana whakahono, they extended it to the Reserves Act and Local Government Act and a range of other matters as well. But perhaps at a further workshop, we could take councillors through that.
Yeah, so in terms of requests for fast track notification in relation to iron sands and things like that, is that part of what this requires?
It's not part, no, through the chair, no, it's not required to be addressed under the mana whakahono.
Okay. So it would, I mean, have you read the mana whakahono that have come in, the draft, for example?
I have reviewed the request. Is that the, through you, Chair, the table that is attached to the agenda, councillor? Is that the one you're referring to? From
specifically the Ngāti Mahuta one that has come in that is very detailed. Yes, it's got a table in it.
Yes, I have read that. Well, I've reviewed it, but yes, I have. Yeah. But I mean, there's a whole lot of detail in there that's going to need to be worked through clearly as part of the negotiation process.
If I can just help again, and clearly the legislation, there are some things that must, and there's some things that may, and the things that may include consulting and notifying on consents and extent to which limited notifications given priority and so on. So it's in the May. Yeah. That's in the May part of it that they want to discuss.
So I'm just wondering through you and the chair whether it would be useful to have a privileged legal report on the contents for 58R and what's been requested in here, so that we know when we go there what we should be, must be doing, and what we might be doing, and what we may not choose to do. Oh no, the people who go there know what the rules are before raise expectations, because there's a lot of expectations in here, and there will be Hauraki ones as well on October the 2nd. So,
all right, Chris.
Thanks, Madam Chair. I'm really just going to pick up on the subject that Noel was picking up on. Our ratepayers can't be treated as if we shouldn't be totally responsible for resourcing these activities. If that's the case, then council is going to think. As far as I'm concerned, we have allocated significant resources. They need to be notified. That is cap in terms of what's ratepayers. And if they want to engage in these activities, then they are the ones that are going to have to start themselves prioritising what's most important. That's the approach that I will next term. Thank you.
I think if anybody was no.
If I can go back to Ben's point and through for your friend Paul, Ben got you to read out the compulsory ones. If I can just go back to the first one, if you could read it out again, please.
Certainly, thank you. Through the chair, it says the agreement must record how an iwi authority may participate in the preparation of or change of a policy statement or plan, including the use of any pre-notification or streamlined planning processes under Schedule 1 of the RMA.
Okay, so we've currently got our Waiora Committee, and that is being formed from the 5 River Iwi JMA groupings who deal with the freshwater issues under
Yes.
the existing RMA. If those are not changed in the RMA by the government when it announces, I read that section that would allow the parties to these agreements to not burgle, but ask for a seat at the table in the Waiora Committee, even though they are not principal partners, because that is covered in that statement you've just read out. Have I got that wrong?
Yes, thank you, through the chair. So you're correct, councillor, that the iwi could ask for that, but the reality is that what the council could equally say is we have these existing mechanisms in place. They're designed like this. We'd like to make sure that either you feel comfortable that you are represented through that process, or if you don't, are there some supplementary things we could do? But it is open to the council to say we don't want to reinvent the wheel or unnecessarily duplicate processes. If I may, just the other thing I would add, that in terms of this next type of hui, this next hui that you're about to have, often in these processes, those are rangatira governance level hui, where there are certainly in the previous ones I've been involved in, there would not be an expectation that councillors would be responding to individual line items in a table and having to respond, do we agree to that or do we not? It's often dealt with more at that leadership level. This is our aspiration. This is what we're trying to achieve. A commitment to the process, and but certainly my experience is those matters need to be dealt worked through in some detail with people like Tracy and her team to work out what will actually work in practice. How does this fit with what else is going on? What's an efficient way for both the iwi and the council to move through this process? So, as I say, there's still a lot of water to go under the bridge, and I certainly my recommendation would be not to be too concerned about the first hui. It's really just a setting the scene hui, if I may.
I'm not worried about the first hui. It's the subsequent ones, and I've got a lot of experience in local government, and the reality is I've learned from Hapu and from Marae that they tell us, and have told me regularly when I've been on the previous council and this council, iwi was set up, the iwi authorities have set up to deal with settlements. Iwi don't necessarily represent what the Hapu or individual Marae want. And so this is where I think the Marae and Hapu are getting organised, because they are finally seeing a mechanism in which they can deal with local issues. So I suspect there will be more of these, and it's a matter of how we deal with them going forward, because the iwi doesn't necessarily, they're dealing with the whole region, the whole area, whereas Hapu are more related, like this one here, iron sands. That's really specific to an area in the region. And so I think we've got to be careful in how we go forward and the precedents that we set and expectations that we give and aspirations. That's a really big thing that we need to think about. Thank you.
Just 2 points. One is, if we begin to enter into these whakahono, for example, with Ngāti Poa, and then we find that Tamatara also has a claim over the same area they're talking about. I mean, I've seen the maps for each of the iwi areas, and they do tend to overlap. How are we going to know who are we representing, and are we binding ourselves to one iwi over another that hasn't yet put one of these requests in? That's a question for Paul.
Yes, thank you, through the chair. So, no, it's a very good point, and it is very common for these agreements to be entered into with a particular iwi in an area where there are multiple overlapping interests, as there are in the Waikato. So we often include a clause saying exactly that, that there are the parties acknowledge that there are other groups with interests in this area and they need to be dealt with appropriately as well. And that's in the mana whakahono o rohe for Tūrangi Tukua as an example.
And finally, through you, the Chair, do you think it would be useful to have a private legal opinion setting out what we must do, contrasting with what has been asked, so that we've got some knowledge moving forward going to that meeting in September?
I think that would be useful guidance.
Yep, point noted. We will ask Paul to help us out with that. Thank you.
Chris,
Suggestion as to who using
come,
that.
go.
I have a
closer.
suggestion as to who we should be using for that advice, Madam.
All right. Anything further on this? Any other questions? Oh, sorry, did we have? Nope. No, if not, hey, thank you very much, Paul, for joining us today. Much appreciated.
Thank you.
Anything from you, Molly? Nope.
Nothing further. Thank you, Council. It's been a really long day. I really appreciate your contribution to our discussions. Really helpful.
Great. Well, with that, we'll call the workshop to a close. Just wondering if we've got a, there we go.
Thank you, Madam Chair. I'll just close with a karakia. Unahia, unahia, unahia mai te uru tapanui, kia wātia, kia mama, te nako, te tinana, te hinanaru, e te ara takatu, koe rā e rongo, e whakaria aki ke runga, kia tina, haumie, huie, tai kie.
All right,
Thank you.
workshop closed 2 o'clock. Thank you.